Professor Koskenniemi's many achievements are well known, but I would still like to take a moment to mention just a few. He is Professor Emeritus at the University of Helsinki, has held visiting professorships around the world, and has received honorary doctorates from the universities of Uppsala, McGill, Frankfurt, Tartu, and the European University Institute in Florence. And Brussels, not on my list. Thank you. Okay. He is a member of the Institut de Droit International. He was a member of the International Law Commission and early in his career served in the Finnish diplomatic service. His work has profoundly shaped the field of international law. Exploring the relationship between power and law, Professor Koskenniemi laid the groundwork for critical legal studies in international law through his groundbreaking book From Apology to Utopia, and later paved the way to what we now call the turn to history in international law, with his rigorous works in intellectual history, first in the Gentle Civilizer of Nations, and later into the uttermost parts of the earth. I have followed this trajectory in my own academic career, in which my political commitments to understanding global inequalities and the structural legacy of historic injustices led me down the path of critical legal studies and inquiries into the history of international law. My generation may be the one most deeply committed to carrying forward the legacy of this critical international legal scholarship. And this is no surprise, given that we were met with enormous generosity, with opportunities to test our intuitions, to exchange ideas freely, and to take part in the very shaping of this field through many events explicitly geared toward early career scholars, often hosted by Martti himself and other senior academics in critical international law. So let me conclude by thanking you, Martti, for a rigorously intellectual yet deeply generous legacy of critical international legal thought, one that has allowed a whole generation of scholars to see and articulate things that might otherwise have remained incomprehensible. With today's lecture, the journey continues. With your finger once again on the pulse, we will hear about what we might later call the turn to the social in international law. Asking about the very constitution of the social as something that might not primarily be understood as a byproduct of the state and its laws seems to be a preoccupation that we now find not only in ever more pockets of critical scholarship, but also in contemporary political debates across the globe. It is, in this sense, a reflection of our current zeitgeist. So with no further ado, let me thank you once again for coming to Amsterdam and for delivering your lecture on the law of an international society, reflections on the concept of the social in international law. The floor is yours.
I'm constitutionally unable to speak sitting down. Thank you, Andrea, for that lovely introduction. And my apologies for raising expectations which are impossible to meet. The lecture today will be on work in progress. I've given this lecture 2 or 3 times, and it changes constantly. Also, the point keeps changing. So if you have seen a video of an earlier version, you may be assured that I'm not going to go the same way this time. It's also a part of the critical inheritance. One never knows what one is going to do next with the same topic. So anyway, so I was brought to this topic, the idea of the social, with the repetition in the course of my career of this topos of international society by other people in other contexts numerable times. In the UN context, for instance, people constantly talk about the international society doing this and doing that. And I started to wonder whether that topos has any substantive sense in the present. When did it come in and why did it come in? And it was very rapidly clear that it is an oppositional topos. It people who talk about international society think of themselves as critics of the center. People who are in some ways dissatisfied with the way the international world works, dissatisfied especially of statehood being at the center, wanting to look beyond statehood and trying to imagine that the international in some relevant sense is like what we call society at home, however we conceive that thing closer to us, and that we can speak of an international society in those terms. And I'm going to now go rapidly through the stages, the relevant stages that I see in that debate. Although this started out, like all of my work has always started, as a linguistic inquiry, as an inquiry into the uses of expressions, the point obviously is about politics. It is about the justice and especially the injustice of the world that is transmitted to these languages in complex ways. Okay, so let's see if I can get this to work. Not the first time.
You should have tried before, right?
Okay. So let's see. So I start where I often start these things before modern international law was born. Modern international law was born, as those of you know who glanced at the Gentle Civilizer of Nations, according to me, in the last 2 or 3 decades of the 19th century. It was born as a reaction against what was earlier on, and the thing that was earlier on was this. So Georg Friedrich von Martens comes from a long and powerful Göttingen tradition of natural law when that tradition was ending. He was the last professor of natural law and public law in Göttingen of his generation, of the natural law variant, and he knew that he couldn't continue as a natural lawyer. He needed to figure out something else. And what he did was that he wrote a completely new book on law of nations, Précis de droit des gens modernes de l'Europe. Modern, he wanted to say, in the first edition in 1897, and then many, many editions in English, in French, in German, etc. And the point of that was to, again, reject an earlier tradition, the natural law tradition. And therefore, this is what he wrote, that in order to be a professional person thinking about the application of law in Europe, then you had to think of it in terms of what the principal European states do. And so his précis was a re-articulation of European diplomacy as a legal system. So what diplomats do, they manage a legal system consisting or based upon treaties, but other declarations as well. He had a good research assistant. I always assume when he, in his lectures, he started to distribute acta, diplomatic acta for his students. And the most scandalous of all, he taught in French and not in Latin, because he wanted to teach these boys in the class to be diplomats. Because what he thought what legal education would be, it would be to teach diplomats to manage a state-based European order, or an order based upon European states and their diplomacy. And in his précis also, he redescribed this new field, no longer a natural law field, no longer a Hugo Grotius field, as äußeres Staatsrecht, that is to say, external public law, which from my perspective means that he didn't imagine an international society. There were just states that related with other states. And the law that was applied was the external public law of those states, and not, as somebody might have suggested, although the vocabulary wasn't present at the time, a law of an European society or international society. So that's the starting point. European statehood. Now, in the first decades of the 20th century, of the 19th century, the social question starts to appear. Industrialism, mass poverty, the question of labor movement, labor. And the person who articulated this new sense that the social question and these incidental questions relating to the social question, poverty, the labor issues, problems of industrialism, that they could not be articulated in terms of Staatsrecht specifically. They were not about public law of states. They were problems relating to how people led their lives in what Hegel then called civil society. Of course, the topos itself, especially the English version, civil society, had an earlier life. It had also an earlier life in France. So Rousseau, for instance. But when Rousseau used société civile, what he meant was state. And the same thing on the earlier British side. Now, Adam Smith is someone who already did use the notion of society in a sense that was clearly wider than the state. Did it include the state? Well, in Smith's Wealth of Nations, maybe it did. But anyway, there was a debate in the early 19th century about how to deal with those questions of mass poverty, which were not national, because that mass poverty was everywhere in Europe. But it wasn't that the state could control it or that it was a state-created thing. It had to do with trade, social life, as we would call it. And so Hegel, in his outlines of the philosophy of right, made this famous threefold order of the spaces in which we spend our lives: state, family, and between those, this thing, civil society. Hegel was a close reader of Adam Smith, and his understanding of civil society, this space between the intimacy of the family and the public realm of the state, was mostly about commerce, trade, production, etc. He called it the realm of need. And he said that that's a space that's not limited to states. It's space that's widening constantly. And he thought, and he in his writings on Völkerrecht, on international law, he used the vocabulary that he took from Martens äußeres Staatsrecht. So external public law. He didn't think there was a law that would have dealt with this middle sphere, the sphere of civil society, in a separate way. But other people did. And the first person who, from my study, is an important person, and I've published on him now, is Lorenz von Stein. Lorenz von Stein started out as a conservative student, traveling from Kiel, where he was born. Before he started his legal teaching in Kiel, he later on moved to Vienna. He, like many young boys, he traveled around in Europe and ended up in Paris. And in Paris, he saw new things happening. So there were mass movements of people. There were people who called themselves socialists because these people, the Saint-Simonians, for instance, the followers of Fourier, those people were thinking of the problems that industrialism and poverty and urbanization, especially in Paris, had created. And von Stein stayed in Paris, started to be in correspondence with some of the early socialists, and published two books of importance in Germany. Der Sozialismus und Kommunismus des heutigen Frankreich, Socialism and Communism in present France, 1842. And then another work. And the point of that work was to bring to his German audience the understanding that this thing that's going on in France, labor movement especially, now remember he's a conservative, labor movement, you have to take it seriously because otherwise it will overwhelm Germany. Another person, and I'll come back in a moment to him, other person, a more mainstream person is Robert von Moll. Robert von Moll in the early 19th century was probably the most famous German public lawyer, general public lawyer. He was a professor at Heidelberg, but he got elected to the Frankfurt Parliament in 1848, the year of revolutions in Europe. He was a conservative liberal, but he was a liberal and he wanted Germany to have a constitution. And so he got elected to the parliament of the first German Republic, declared in Frankfurt, and not only a parliamentarian, he got elected as the Minister of Justice of this newly formed German Republic. Now, as you know, the revolution collapsed, or so the reaction set in, military oppression set in. Many of his comrades and colleagues and friends had to ask for or request asylum in other countries. Many went to Switzerland, Britain, etc. He was so famous that he didn't have to. And so surprisingly, he could return to his chair in Heidelberg. Returning to his chair in Heidelberg, he started to publish things such as, for example, a critique of the kind of European public law that Martens had made famous and that most of his colleagues had been practicing. In a long text, Die Pflege der internationalen Gemeinschaft als Aufgabe des Völkerrechts. The assignment or the purpose of international law is to bring about an internationale Gemeinschaft, an international society. Now, here is some of the new vocabulary that these people introduce in public law debates in Germany. So, Gesellschaft. So, Lorenz von Stein already speaks with confidence about Gesellschaft. He links with that notion ideas such as labor, interests, and social movements. He talks about Klassenkonflikt, and he says that this Klassenkonflikt, has to do with a conflict between those who own property and those who do not own property. Now, obviously, this is happening at the same time as other people are putting these words. I am insisting that Lorenz von Stein thinks that he is an innovator and, in a sense, is an innovator. And he wants to explain to his legal audience, his conservative legal audience in Germany, as to what they are going to have to face in the near future. And he says that the time of this old Völkerrecht is over, that there must be something else that deals with the international lives of peoples. And in a late essay, one of his last long essay, he writes on Völkergesellschaft as a Staatenverein. So a community of peoples as a federation of states. All of this vocabulary obviously is tentative, and you can see him trying out directions. And von Moll insists that there should be now, that it's no longer sufficient that we public lawyers, we mainstream public lawyers. Remember, he was the most famous German, or highly appreciated German public lawyer at the time. He had been traveling in the United States. Some of his work had to do with an interpretation of the US Constitution. And he says that now what we need is a scientific way to establish a Lehre von der internationalen Gemeinschaft, a doctrine of international community or society. Now, at this time, 1860s or so, societies, little associations, I should say, to make the distinction, associations of professional men are established across Europe, which try to develop something like a social science. Here there are some of them. The most influential is the one that I mentioned here first, l'Association internationale pour le progrès des droits des gens, progrès des sciences sociales. Why I say this is the most influential, all the persons who 20 years later establish the, or 10 years, 13 years later, establish the Institut de Droit International, the Institute of International Law, are members of this association. And in the context of that association, start to think that we should have a way to deal with the Europeanization of problems and to deal with colonialism. And those other associations, then the Institut de Droit International, to which I come in a moment. But then this idea of society, an idea of social science, met with tremendous resistance by a number of powerful legal intellectuals or lawyers, how you want to say, an intellectual and a lawyer. Heinrich von Treitschke, for example, an interlocutor with Bismarck and one of the founders of the realist school of history and international relations, you can say. So he wrote his Habilitation as an effort to refute what Robert von Moll was doing. So his Habilitation, Die Gesellschaftswissenschaft, the social society, ein kritischer Versuch, a critical analysis. And he says that the object of the science of state actually covers the whole external field of statehood. It covers the lives of individuals, it covers the life of industries, it covers the life of commerce, it covers everything. Of course, there are these individual aspects of our lives of families, of all kinds of relationships, of commerce, and so on. But all these phenomena, we can call them social phenomena, but they come under the science of statehood, the science of governing statehood. Now, Treitschke, obviously, is a part of a political project, the Bismarckian project of creating Germany. And the last thing the Germans wanted was to start to believe that, oh, it's fine, we live in a German society. No, we need the state and the pull to suggest that we are already joined together by these mundane activities of our labor, our work, our families, etc., would take the momentum off from that project. Now, Johann Caspar Brunschli, I would say, the most influential international lawyer, once that thing gets going, in the last 2 decades of the 19th century, agreed. Although Brunschli was a Swiss person, he was a refugee from Switzerland, from the Civil War. He was a fighting Protestant, you could say. He became von Moll's successor in Heidelberg, and from that position pushed forward this idea that there could be an international law of a kind, but it's a law based upon states. And this idea of society, it really has no space, because, he explained, there are 2 things that we know. We know the state and we know the individual. And sometimes individual freedoms, and he was speaking of actually Menschenrechte. He's one of the first public lawyers who openly advocated an international Menschenrechte. He was also a racist and an anti-Semite. So he was saying, well, we can have and we should have more Menschenrechte, which only means that the fear of state authority becomes smaller and smaller. But sometimes we need to expand state authority, the meaning of which is that individual freedoms become small. There is no space in between, because the world of our lives among each other is divided by the life of statehood and the life of Menschenrechte. So no space for social. And of course, Bluntschli was also an interlocutor of Bismarck's and actor in the drama of German unification. And so when Bluntschli then became the intellectual father of this new discipline, international law, established as it was through the establishment of the Institut de Droit International on the 8th of September 1873, that institute didn't think of itself as a law that it would expound and study, didn't think of it as a law of an international society, but a law of a civilization. So the members of the Institut de Droit International in their statute wrote that the Institute would be the juridical conscience of civilization. And the vocabulary of society did not enter it. Now, the Institute housed these people that had been thinking about how to govern Europe as a social field. And they took two directions. On the one hand, they started to work, the Institute had two work projects, how to deal with private law relations in Europe and how to civilize those relations, especially. They were against death penalty. They thought of themselves as in favor of the women's cause. They were abolitionists in terms of alcohol. I mean, standard centrist liberals of the period. And they thought that as growing civilization in Europe. And they were racist and colonialist on the other hand. They wanted to civilize the colonies. They were in favor of official imperialism. They congratulated King Leopold II for his wonderful humanitarian venture in the Congo. And he thought there should be more of such things. So Europe, where civilization meant getting European individuals to move about more easily, to marry more easily, to visit the galleries in Paris and Rome more easily, and then to civilize the rest of the world. No society. Now, an outsider from this group is Jelinek. Jelinek started his career in Vienna. And in this story, Vienna will be really important. Jelinek started his career in Vienna, where he wrote his 2 or 3 first books. And one of them was directly on international law, on the concept of the treaty. There was also a book on the concept of federation in Europe. I'll come back to those in a moment. But he was faced, so his appointment as professor of this newly established discipline of international law was blocked because of anti-Semitic propaganda against him. And so he left Vienna and found himself in Heidelberg. And in Heidelberg, in the due course, he published this immensely important work for European jurisprudence in general, the Allgemeine Staatslehre in 1900. And he says that which is badly translated, but you can't suppose translate any other way, the general theory of law and state. Allgemeine Staatslehre. And he thought that this Staatslehre should have 2 sides. There should be eine allgemeine Soziallehre des Staates, which is the bulk of the book. And then there should be a smaller much smaller part and a less interesting part, the allgemeine Rechtslehre der Staat. So, and the book in itself is a series of really interesting reflections on the distinction between state and society, through this distinction that he makes between a social science of statehood and then the legal science of statehood. And he makes this distinction by thinking that the legal science has to be what the cutting edge legal science in public law in Germany is now the von Gerber and Laban school, and that school is known as the formalist school of public law, which is to say that the school suggests that law is enshrined in formal manifestations of the will of the state. So this is the will theory, the will enshrined in formal manifestations such as laws, treaties, etc. And that the task of the legal science, the exclusive task of the legal science, is to study those norms as they are put forward in these formal documents, to interpret those formal documents. So not as to how the world is or how the state is, but how it should be in accordance with those things. He acknowledges that there are two problems here, which he gives the names, the problem of Legitimität and the problem of die normativische Kraft des Faktischen. So the problem of Legitimität. So when Jelinek says that law is the emanation of will enshrined in a formal document, he acknowledges that this doesn't tell us whether the will has been legitimately constructed. So this is HLA Hart's gunman problem. Do you assent because somebody holds a gun in your head? So he knows that problem, but he says we will have to come back to that. And then he acknowledges that although law is an emanation of will, it tends to be, if we look around, that facts accumulate to law. Facts of power accumulate. We have to come to that later, he says. As I said, the part on the Allgemeine Soziallehre is much more interesting, it's much more powerful. The tragedy is that he thinks that law is not what deals with interesting and powerful things, but instead the interpretation of formal instruments. Okay, so two other colleagues of his, Karl Menger. Karl Menger is a professor at the law school in Vienna, working there at the same time as Jelinek. They are in contact. I don't know exactly how close, what they thought of each other, but they were trying to do the same thing, trying to invent a scientific way to study the lives of not only the Viennois, but of people in European world, and to think of that world as a society in some ways. And Karl Menger suggests that, as like Jelinek suggests, that we reject the organic theories that have been. The society is not an organ. It's a silly metaphor. You can use it as a metaphor, but you actually shouldn't, because it hides the fact that it consists of individuals. We are all individuals, and we want to be individuals. We are liberals, after all. So we're individuals. But how do we interact as individuals? Menger says, well, we interact through trying to fulfill or satisfy, as he says, satisfy our needs. And he suggests that it's possible to think scientifically about the way in which we live by analyzing our needs, the goods, Güter, the goods that satisfy our needs, and the actions that we need to take so as to have those goods that then satisfy our needs. And he says this is a particularly scientific way to go about it. He makes that point in a conversation with the German Historical School of Economics. The German Historical School of Economics, very powerful school from the early 19th century onwards, the first real school of economics as science, suggested that economics is something that's specific to each society. In order to understand the economic actions of the Dutch, you should know Dutch history very well. You should know how Dutch companies have developed, how Dutch enterprise entrepreneurs have acted, and so on. Now, Karl Menger says, that's not science. That's just recounting facts. You have to extrapolate from facts things. And so he comes with this enormously important innovation early on in his studies, which he then uses to attack the German economists, Gustav Schmoller especially, but also the others, by saying, well, from those facts, we should first analyze what are the important aspects of those facts that unite those facts to some ideal type. He doesn't use the word ideal type, but that's what he means, that all of these disparate facts have something in common. And it is by studying that what is common to them, and not studying those facts because that's just empirical listing of things, but extracting the commonness, we can have a science. Menger is known as one of the two main founders of the so-called marginal revolution. Menger is the father of, one of the two fathers of neoclassical economics in law school, as a lawyer, trying to understand what this thing in which we live is. Now, Jelinek notices that he has this new idea, and he writes, the last thing he writes in Vienna is his study of federations. The study of federations starts with Jelinek confessing his despair that for many years he's trying to have a theory about federal states, but then he studies Switzerland, the United States, and the Zollverein of Germany, and he finds that they're so completely different. What can he say? But now he has this thing that he doesn't have to study them. He can isolate the determining elements and he can study them, and that's a theory of federation. He goes to Heidelberg and becomes the mentor to this younger person, Max Weber. And Max Weber, on Jelinek's grave, thanks his mentor for having opened the way for him to think about the world in the ways that Max thinks about the world. And of course, Max Weber is the father of sociology, society as meanings of individuals that relate to their behavior. Now, something that I find really interesting in all of these three men, Jelinek, Menger, Weber, each of them think of this as really important, is not to think in emanationist terms. This is Weber's term. That is to say, not to think that individuals are living in some kind of collectivity, the organic theory, for instance, or the theory of the nation. Or no, we are all individuals. And they provide three different ways in thinking about society as a group of individuals interacting. Unfortunately, Weber takes from Jelinek also the understanding of law, namely law as the correct meaning of a legal proposition. So, not a good start for the 20th century for lawyers, but an excellent start for economists and sociologists. Now, of course, there were also non-Germans in this business. So, as you know, Emile Durkheim in Bordeaux was also trying to respond to the question, how is it possible that after tradition, after the breakup of religious belief, after our lives out there in the countryside have been put to pieces when the boys and the girls go to the town. Some become big bosses, others become laborers. So can we still talk about France as a society or as an entity together? And so he comes up with this explanation. I'm sorry that I repeat something that's really, really basic, but it has an international life, this thing. So he suggests that there are two kinds of ways of understanding the solidarity as an empirical notion, solidarity that keeps us together. Traditional society was kept together by all people doing the same thing at the same time. So they all woke up when the crow, with the crow at 5 o'clock in the morning. They all went to the fields. They all had their breakfast at 7 o'clock. They all beat their kids at 9 o'clock, etc. Then to church at noon, etc. They all did the same thing. Of course, you feel that you are in community because you are. Now, modernity, and that he calls mechanical solidarity. But then modernity operates differently. And he says, well, it's true that we lead these different lives. Some are in the countryside, some are in the cities, some earn lots, some earn very little, etc. But we are all interdependent, so that the factory owner and the shoemaker are completely dependent on each other. The factory owner couldn't own the factory had he not the shoemakers, and the shoemaker could not have his penny without the factory owner paying that. So, and he says, well, this is organic solidarity. He gives it the name. And the French think that's great. Because it allows us to live like we've always lived. And we have an explanation to it, which sounds really scientific. And the internationalists in 1890s and 1900s take this up. And they develop a doctrine of solidarism. There is a specifically exotic legal variant of solidarism, which is this. This is put forward by one of the most important lawyers in France in the 1890s, also a person from Bordeaux. And this comes directly from the teachings of Durkheim, Léon Bourgeois. Léon Bourgeois, very appropriate name. Léon Bourgeois became a long-standing foreign minister and prime minister of France. He was also an academic. He had I don't know whether it was a professorship or a visiting professorship at the University of Paris. He wrote books on solidarity in which he became the first president of the Council of the League of Nations. And he wrote this book on solidarism, where he suggested that human beings are always linked together with what he calls quasi-contract. So when we are born, a quasi-contract is created between the baby and the world. The baby couldn't survive for a day without the mother and then the family and everybody taking care of the baby. And so the baby is born indebted to the people around the baby, and that's a quasi-contract. And that the idea that we are all bound by this quasi-contract is his, again, individualist idea of society. And the most famous representative of this view, organic solidarity, that we all human beings as individuals, not as states, as individuals are bound together organically, not as an organism. Again, the metaphor is dangerous, but by this system whereby we expect from each other things and we more or less receive those things for our lives, which is to say we are called upon to make our own performance in this world of quasi-contract. And Sell, in his main work, asked the question, well, where do the rules of law come from? Du fait social lui-même, the social fact. And the social fact for people, for the solidarists, for the Durkheimians, and for French international lawyers, at least until the 1970s and 1980s, was precisely this interdependence that links us together, which is a critical position. It's a critical position against the idea that the world is linked with statehood. And in the interwar, while the solidarists are trying to understand the League of Nations, trying to understand the international world through the language of organic solidarity, the Weberians are in a more realpolitik mode, thinking of it in terms of states operating, but nevertheless states very rapidly deconstructed into specific power relations between the ruling elite and others. The lawyers in the League of Nations and in the academy, the Germans, try to operate with a society of states to make this combination of the idea of society, international society. Yes, it's a society. Yes, we are interdependent, but we are states, and that the individuals remain invisible. So Max Huber, a famous Swiss lawyer, wrote the first longer essay with the title Die soziologischen Grundlage des Völkerrechts, and there expounded this sense of states through trade, commerce, technologies, constantly interacting more and being more linked, by articulating that the states have their interests, and that it is by the operation of those interests, or through operating those interests, that states become indebted to each other through the modern communications vehicles, through trade, and also various cultural links. The ideas of public opinion and folk psychology also spread at this time. None of these essays, Dietrich Schindler from Zurich, professor of international law from Zurich, both the younger one and the older one with the same name, from before and after the Second World War, our political realists become international lawyers, focusing on this idea of interests as the culmination of the legal profession. So lawyers should be aware of interest. They are instrumentalized in favor of interests, and that is the social, what one can say about sociology. Julius Stone, who was he was an original of Britain, a Jewish, a British student, went to Harvard and became Roscoe Pound's assistant. And under Roscoe Pound, who famously produced this functional view of law in general, one of the early legal realists, moderate legal realists, he then wanted to bring into international law the kinds of modern sociological ideas prevalent in Harvard and in the US empirical sociology of various kinds. So in his lectures at the Hague Academy in the 1950s, he inquired on problems confronting sociological inquiries in international law. This is a very pessimistic series of lectures, because Stone thinks that, well, yes, it's true that the law exists in the minds and in the behavior of people. So it's a basic realistic idea. It's not the treaties, the form of the treaty, the decision of the conference. It is what people think about those, how they act in relationship to those. Now, unfortunately, in the last chapter of this, he says, we should, of course, interview these people to know what they think about their actions. But we can't interview diplomats, because even if we try, we know that they are, their profession is to lie. And so we don't get it. And so we can't really have, and he suggests possible lines of inquiry as to how young sociologists could go to the UN and other places with a mic and a test of questions. And he thinks, well, something may be achieved, but he says it's really tough. And I think I would agree with him, if that's what you think sociological inquiries are about. Now, about this time in the international relations departments in Britain especially, a very strong push towards the idea of international society emerges. Many of you, I'm sure, know this, Hedley Bull, the anarchical society. And it's hard to know how to relate Hedley Bull's writings to anything that I've said previously, so to Weber or Durkheim. He writes as if he hadn't read these people, but obviously he has. I don't want to suggest this. He comes up with this idea that we can and should think about the international world as an international society, but it's an anarchical society. It's anarchical in the sense that it doesn't have powerful infrastructure, powerful cultural or political infrastructure on which it could be states. We do have a certain number of states conscious of certain common interests and common values, which is the kind of language that the Gentle Civilizers, that is to say the late 19th century lawyers who established the Institut de droit international, would be quite comfortable with. And he suggests that it is this internal aspect of the rules, so they internalize a set of rules through their cultural relations. This is above all diplomats, business people, people who have a cosmopolitan sensibility. They are able to manage international institutions, and that fragmentary set of institutions and ideas in the heads of people is what you can then study. And in the international legal field, the notion comes up in the German tradition. Obviously, the Germans are very keen, especially the post-war West Germans, are very keen to talk about an internationale Gesellschaft. And here is Hermann Mosler. Who is Hermann Mosler? Hermann Mosler is the most important director of the Max Planck Institute in Heidelberg, or the Institute of Foreign Public and International Law, who gets it going in the late 50s, 60s, and 70s. He's a long-time director. He also becomes the first West German member of the European Court of Human Rights and the first West German person at the International Court of Justice, and the first West German person to give a general course at the Hague Academy. So you can't get higher to the top than that. And his manifesto is that the international society is a legal community. And he thinks pretty much like Hedley Bull. I'm thinking they both carefully try to map a cultural realm of interaction between cosmopolitan diplomats, business persons, and so on, operating in favor of their states in these institutions, and accept that they are bound by a certain set of rules. There's a society there. The English school, the School of International Society, has a really hard time expanding outside Europe. They try, and in a recent work, the expansion of international society, which is also the expression as if from the late 19th century. The idea is that the international society exists first in Europe, and then it expands everywhere. Europe as the heart of expansion, development, and everything. The states, when they start to think of what the work of the state is to develop the state, to see for the growth of and the operations of the market, becomes part of the international society. I couldn't come to the present without mentioning what I think of as the most important intellectual breach in the post-war era, namely Wolfgang Friedman's The Changing Structure of International Law. Friedman was a refugee from Germany, first taught in Australia, then at Columbia Law School. And The Changing Structure of International Law, 1964, makes this total break with the state-centric idea, suggests that yes, UN and international state institutions are important, but there is much more there. Law is, as I've quoted here, an instrument of social order. He thinks social order goes way beyond statehood. It links us all together in various types of power relations. He wants to open international law as a profession, the way it's taught at schools, to the works of the new international economic order, to human rights, economic cooperation, welfare. He talks of the European Economic Community as something that shows a model to the world. He wants to end it with states, and in some ways, his ideas are overtaken in the 1980s with this idea that there is an international society, and that society is only marginally to do with states. It has to do with the transnational commercial trade, economic relations that expand. And of course, Hayek is a late follower of Menger, a late follower of the neoclassical economists, neoliberals, one could say, maybe an ordoliberal as he becomes older, with the key ideas being that society is an aggregate of individuals acting spontaneously in order to fulfill their desires. Not only that, but individuals whose knowledge of what should be done in order to create welfare and to benefit the community is greater than that of any plan produced by any public entity such as a state. A state nevertheless has a role to facilitate the creation of the market, the social as the market. And in the famous or infamous World Bank report from 1997, this idea of the state as facilitator reproduces very programmatically what we nowadays call, or they call already at the time, an ordoliberal idea of how to rule the society. The society basically rules itself through inter-individual interactions, but the market may be distorted by all kinds of elements within and without it, and the task of the state is to intervene there. The 1990s international law languages explode. Governance, pluralism, transnational law, fragmentation, deformalization, etc. All of these languages' efforts to grasp what seems like social developments, but social developments hard to put within any of the available, especially legal vocabularies or other vocabularies. Nevertheless, people try and run with vocabularies and become famous and talk about things such as fragmentation of the international society and transnational law and so on. I'm not going to take a position on that. This is my last slide. What I want to say is that I think there is a sense, especially in the critical crowd, that we do live in a moment where many of these languages are up for grasps, and we can see some of them ruling over others. The social is the name for a struggle, but it's a name for a struggle articulated in a particular set of historical, legal, and public connotations. It's not innocent of what has been in the past. To talk in the language of the social is to historicize one's own position and to produce a particular developmental trajectory that looks also forward. Law's role here, as David Kennedy and I tried to put forward in the COVID book that we wrote. So this is a series of conversations on Zoom and then transcriptions edited. I just checked from my computer 8 times in order to get to a publishable form, which is an effort to try to think about the critical inheritance. Now, what are the tasks, what have we learned, and what we don't know, and what the role of the law is. It pushes forward 2 two types of role for law, or two types of inquiries into the roles of law in the social. On the one hand, the law participates in the framing of the social. That's a familiar metaphor, a familiar idea. Law gives us a series of languages through which we articulate social relationship, and it enables lawyers and other people to articulate some things in such a way that they are felt as true, and true in such a way that other people are called upon to yield to that truth. So to articulate legal truths. And those two things, framing a larger scope that law does, articulating a smaller scale scope that law and lawyers do, opens, we suggest in this book, avenues for studying society and power in society. Now, again, the book makes the argument that international law is not very interesting, that law is hugely interesting, and that we should inquire much more deeply into how law frames our relations and how people are empowered by articulations about what the law's truth in a particular situation is. And as I said, especially in such a way that who has to yield to that truth. And focus is, especially in David's work, I suppose in mine too, is on expertise and imagination. How it is that people who are regarded as competent native language speakers of the legal language, how it is that they imagine what it is that they are doing. Okay, that's where I end. Thanks for being so attentive. We have some time.